Subscribe to our YouTube channel and press the bell icon to get the latest updates.
Now, the monsoon session of the Parliament has ended, and like I had promised, I'll be taking up a few bills that were passed during this session and explain them to you in the upcoming KYC episodes. Now, the bill that I have for you today is the General Insurance Business Nationalisation Amendment Bill. This bill does have several great implications for the country's economy. It was passed by the Rajya Sabha on 11th August amid major protests from the opposition. Basically, all opposition parties wanted this bill to be sent to a parliamentary committee instead of passing it straight away. Plus, the government has especially been, as we know, accused of bulldozing legislation through the parliament in this session, with the parliament turning out to be the least productive in the Modi government's second term. But this specific law was passed within 8 minutes in the Lok Sabha and within 14 minutes in the Rajya Sabha. Now, the government's push for the bill seems to have come because in this budget, the government had specifically promised that it would privatize one of the four government-owned general insurance companies. Privatization of these companies would basically mean that the government's equity or shareholding in these companies would drop below 51%. Now, this new law basically amends the General Insurance Business Nationalisation Act of 1972. This law had basically nationalized all private companies that were engaged in general insurance business in India. So this general insurance basically includes all your motor insurance, health insurance, travel insurance, home insurance, etc. Life insurance companies had already been nationalized in the 1950s by the Jawaharlal Nehru government. So what this 1972 law did back in September 1972 was, in one stroke, it basically nationalized and the government took over the general insurance business of 55 Indian companies and the undertakings of 52 foreign insurers as well. Basically, the Act set up, the 1972 Act had set up the General Insurance Corporation of India, and these 107 companies in total, that is 52 and 55, these 107 companies were amalgamated into four separate subsidiary companies of the General Insurance Company, that is GIC, and four companies were formed, like I said. There was the National Insurance Company Limited, Oriental Insurance Company Limited, New India Assurance Company Limited, and the United India Insurance Company Limited. These four companies were basically spread across the country and their business was spread on geographical lines. So basically their head offices were at Kolkata, which was then Calcutta, one was in New Delhi, one was in Mumbai, which was then Bombay, and one was in Chennai, which was then Madras. Now, let us also understand how this was possible within the constitutional scheme as well. Now, when talking about nationalization, which is what had happened in this case in 1972, one of the directive principles of state policy is usually referred to. This is Article 39, and two clauses of Article 39 are spoken about usually. We have Article 39B, which says that the state shall, in particular, and I quote, direct its policy towards securing that the ownership and control of the material resources of the community are so distributed as to best serve the common good. This is one. Then we have Article 39C, which says that state policy should be directed towards ensuring that the operation of the economic system does not result in the concentration of wealth and means of production to the common detriment. So these are the two articles that are usually quoted. Additionally, Article 31C, which has a very complicated history in itself, and I'll talk about it maybe in one of the other KYC episodes. But basically, this article right now, it protects any laws under Articles 39B and 39C. Basically, if any laws are formed to give effect to what Articles 39B and 39C demand. Basically, these are directive principles of state policy. So, if the state makes any such laws, Article 31C protects any such law from being declared unconstitutional on the ground that it violates Articles 14 or 19. So, for example, if a law is brought in taking away somebody's right to, say, practice any profession or trade or business, by only allowing the state to engage in that industry, even then the law cannot be struck down. This is just by way of an example. If, of course, the law is made to give effect to Articles 39B and C. Now, in fact, there's another thing. The first amendment to the Constitution especially amended Article 19(6). Article 19(6) basically talks about reasonable restrictions on Article 19(1)(g), which is the right to practice any trade, profession, occupation. Now, it specifically said that it was amending Article 19(6) to cover any scheme of nationalisation which the state may undertake. So it specifically allowed the state to make any law for the state to carry on any trade, business, industry or service, and even allowed it to partially or completely exclude citizens from any such industry. So these are some of the constitutional scheme which does allow the state to nationalize certain industries. Now this law, the General Insurance Business Nationalisation Act of 1972, was amended once in 2002 as well by the Vajpayee government, transferring the control of these 4 subsidiary companies from the GIC, that is from the GIC to the central government, therefore basically making them independent companies. Now the original 1972 Act made it mandatory for the central government to have at least 51% shareholding in the specified insurers, that is the 5 companies that I spoke about initially, 4 subsidiary companies and GIC. The new law removes this provision, therefore allowing the government to have less than 51% shareholding, which is what privatisation is, as I had mentioned earlier. So the new law tries to undo whatever was done in 1972 and now aims at greater private sector participation in public sector insurance companies. There's another important change that this new law brings in. The original act actually empowered the central government to decide the terms and conditions of service of the employees of these insurance companies. But now the new law basically allows the board of directors of these companies to make new policies or make changes to the existing employment policies. That's all I have for you right now. This is Apoorva Mandhani for ThePrint. Do subscribe to our YouTube channel and keep following us on Twitter, Instagram and Facebook.